I'd like to welcome you all. I'd like to welcome you all to today's American College of Bankruptcy, Boston College Law School Bankruptcy Law Symposium. Before we started, I asked Ingrid Hillinger how many years we've been doing this now, and we couldn't remember, but it's been at least 10. So we'll call this, for lack of a better name, the 10th annual Bankruptcy Law Symposium at Boston College Law School. I'd like to begin by thanking, I'm Michael Goldberg, I am the Regent for the First Circuit of the American College of Bankruptcy. I'd like to begin by thanking a few people and thanking an institution. Boston College Law School has played host to this program for all of its years, and it is indeed a wonderful host. It's a wonderful place to hold this seminar, and so thanks to the Dean and to the school for allowing us to come back year after year. Second, although she's not in the room, I'd like to thank Ingrid Hillinger, whose determination, hard work, and inspired leadership plays a significant role. There she is. Ingrid, thank you for all of your hard work. And for ensuring that bankruptcy practice will continue for many years to come. Well staffed. Third, thank you to Jay Geller, who's to my left. Jay is our education chair and has done what I think you will find to be a terrific job putting together a fascinating program. So before I sit down, I just want to tell those in the room a couple of things about the American College of Bankruptcy, which is one of the co-sponsors of today's conference. So the American College is an organization that recognizes the achievements of insolvency professionals and judges around the country and really throughout the world. Through its 11 circuits, it puts on programs just like this symposium and many others. Some of those programs include moot court competitions, negotiating competitions, seminars at law schools to discuss bankruptcy law practice, and other similar educational programs. And these take place throughout the 11 circuits across the country. But the college's crown jewel is really its pro bono efforts funded by the college and its foundation. That foundation and the college's pro bono committee provide a significant amount of support to pro bono bankruptcy programs around the country. As of last year, the college it generated grants to 63 of those programs around the country, awarding grants totaling $480,000. Without those funds, it's pretty clear that programs like the program that's here and other local law schools simply couldn't provide the legal services to those who couldn't afford it that they do provide. So those are some of the things that the college does in between sponsoring symposia like this. It is the college's delight to be here today and to co-sponsor this program. And with those remarks, I'm going to turn it over to Jay Geller, who's going to introduce our panelists and get the program started. Thank you.
Welcome, everyone. Thank you for being here. Thank you. Where's Professor Hillinger? Thank you. She's been a great help in putting this together. Thank you to the College First Circuit Education Committee for assisting me in putting this program together. Thank you, panelists, for making the trip and being part of this program. And thank all of you for attending. It'd be a lot of wasted effort if you weren't here, so thank you. Very quickly, an overview of the program for today. We're going to have two panels. For simplicity's sake, I call them the Recurring Issues panel and the Supreme Court Practice panel. This first panel is going to talk about the history, not so much your traditional seminar that you may go to or your typical program where they talk about what the court decided this term or what they decided last term, how they might come out on a case this year. But we're going to be talking about issues that have confronted the court repeatedly since the early 1800s and why they're there, why in fact they keep recurring. And then the second panel, which will begin at approximately 2:40, will be Supreme Court practitioners talking about what it's like to practice before the Supreme Court in the bankruptcy arena and otherwise, and how you get your case before the Supreme Court and how you brief it to try to get 5 justices on your side. So I think it'll be an interesting one for not only bankruptcy practitioners, but appellate attorneys and folks that have an interest in constitutional law. We'll have a 15-minute break after the first panel. There are CLE forms that we'll have up front at the break. We've sought approval for 2.75 hours of CLE credit, so if anybody needs that, we'll have that up front a little bit later. Last thing before we begin, questions and comments. We encourage them. Feel free to raise your hand. I think that there is at least one microphone floating around that will have some, yes, thank you for agreeing to do that. And so I reserve the right, however, to limit that if we wind up not getting to hear from our panelists, because I think they have a lot to say. So we'll just try to keep that under control. We'll hopefully have a few minutes at the end, but feel free to interject with questions and comments. With that, I'd like to introduce our first panel. And I remember thinking about this and saying, how am I going to introduce these people? And I decided to go in alphabetical order so as not to offend anyone. Professor Douglas Baird is at the University of Chicago. He has authored a book called Elements of Bankruptcy. It's in its 6th edition. And I was thinking about trying to talk about all the things he's written and decided I'd rather have him spend time talking to us. But to put aside, or actually recover my Boston accent, he's wicked smart. And I think you'll find that out. And our next panelist is the Honorable Robert Gerber. Robert Gerber served for 15 years as a bankruptcy judge in the Southern District of New York. I think many of you know him from the Northeast Conference. He's been a frequent attendee. Worked on some of the largest cases that this country has ever seen, Adelphia, Lyondell, and of course General Motors, and I could go on. He's an adjunct professor at the Columbia Law School, spent his practicing career at Fried Frank, and a friend and one of the nicest people you'll ever meet in the bankruptcy field. And the last member of this panel, but not least, is James Sprayregen. Again, I think most of you know him. James is one of the, if not the premier debtor's lawyer in the country, if not the world. He has worked on some of, again, the largest cases that we've ever seen in this country: United Airlines, General Growth Properties, one that you might have heard of recently, Toys R Us, and I could go on and on. So that is who we have, and I'm honored to have them here. And we're going to start off with Judge Gerber talking to us about jurisdiction and Article I power. Judge?
Thanks, Jay. Jay's asked me, he's tasked me with the very, very narrow topic of what we talk about as jurisdiction, but which more technically speaking isn't jurisdiction, because that comes out of the Judicial Code, 28 U.S.C. 1334 in the bankruptcy area, and rather bankruptcy judges' power to decide stuff. And he's also asked me to talk about due process in the bankruptcy area. That's a lot of stuff to cover in a limited time. So I'm going to set the table with some fundamentals, provide what I think is a structural framework for an understanding of the most important holdings in this area, and then use the remainder of my time, which hopefully will be the bulk of it, to provide my takeaway from these cases. Now, before I do that, I want to give a lot of credit to three folks actually. One, Professor Ronald Mann of Columbia Law School, who's written a book on bankruptcy in the Supreme Court, a very recent one, and in my judgment, a very good one. And Ken Klee and his partner, Whitman Holt, who've also written a book, actually Ken wrote two, on bankruptcy in the Supreme Court, which helped me sort out my own ideas, which are based on just 15 years of episodic exposure to this stuff. Doug, with no disrespect to your academic colleagues, I'm going to discuss this as the pragmatist that I am, and also with no disrespect to your academic colleagues. Doug is much better this way. I'm going to try to speak in as plain English as I can, and to be as non-technical as I can. So let's get going. And before I get into what are going to turn out to be 10 separate cases decided by the U.S. Supreme Court in what I'll call the power to decide area, again as a substitute for jurisdiction. I need to set the table with a couple of things. There are 2 or 3 people, and I think only 2 or 3 people in the room who are old geezers like I am who practiced under the Act. But understanding the stuff we're going to be talking about is materially assisted by understanding how it used to be in the old days, and a fundamental concept which many of you may have heard about, but which is so important that it's worthy of discussion. And that is that bankruptcy is historically in rem. There are at least 3 major decisions of the United States Supreme Court: Gardner versus New Jersey, Central Virginia Community College against Katz, and Tennessee Assistance Corp versus Hood, which have said that with varying degrees of specificity. So what does that mean as a practical matter? We have a pile of assets in the estate, and we have decisions to make as to who's going to get a piece of the action from those assets and how claims are going to be determined to get the right into the doorway to do that. Now, you're also going to hear that to administer bankruptcy fairly, we have to recapture assets back into the race, the estate, from time to time, most significantly by recovering fraudulent conveyances and preferences. Also, less commonly, unauthorized post-petition transactions, turnover, and the like. But as we go through it today, keep in mind and ask yourself a silent question. Are we talking about dishing out pieces of action in the race? Or are we talking about the asset acquisition process? Because that's going to have a material effect on how we look at these things going forward, or, respectfully, how I would suggest to the Supreme Court that it do it in the next case to come down the road. Next thing that's helpful to understand is the structure of the old Act. We've had a number of bankruptcy acts over the years, 1800 in the 1840s, about 1867, but most significantly in 1898, as it was then amended by the Chandler Act amendments during the Depression era. And the old Act had a decidedly in rem focus, and now you know where I'm coming from when I started with in rem. One was a Section 2 of the old Act, which talked about the jurisdiction of then referees, later called bankruptcy judges, now called bankruptcy judges, to hear what they called proceedings. Proceedings are what we now call, in bankruptcy parlance, cases. And you can always tell an Article 3 judge who doesn't know anything about bankruptcy when he or she talks about a modern case as being a proceeding, when the word really would be case. Conversely, proceedings can now include, and most commonly do include as adversary proceedings, things that come up under the umbrella of a case. So think of it as exactly flip-flopped now from the way that it was in the old days. Back in the old days, and this is where I started as a young associate, bankruptcy courts had what they called summary jurisdiction, which was in what was called straight bankruptcy at the time, what we now think of as Chapter 7, jurisdiction to deal with the assets in which the estate had actual or constructive possession. There was a twist to it because under 311 of the Chandler Act amendments, under an old Chapter 11, and I'm talking about an XI 11, that in rem jurisdiction also covered assets in which the estate had title, even if it didn't have possession of them. But you can still see the in rem focus across the board. By contrast, if a bankruptcy trustee, or in Chapter 11, Old 11, a debtor in possession, wanted to go out and grab additional assets in, such as to recover a fraudulent conveyance, it had to bring what was then called a plenary action. It could be brought in state court, it could be brought in federal court, but the bankruptcy judge or referee, I think I'll use referee when I'm talking about the old act days, could not decide it by means of that summary jurisdiction that I just turned to talk about. Keep that in mind, too, as we discuss the new cases that came thereafter. Now, I want to talk about 10 separate cases that define the modern jurisprudence at the Supreme Court vis-a-vis bankruptcy litigation. And now you'll understand with so many why I'm talking as quickly as I am, for which you have my apology. First, I want to read something to you. I'm reading from, everybody have one of these, a Constitution of the United States of America? Congress has the power, in addition to establishing a uniform rule of naturalization, to establish uniform laws on the subject of bankruptcies throughout the United States. I want you to remember it because when I talk about the Supreme Court cases to file, you're never going to hear those words again. You would be astounded, I would suggest, as to the extent to which a court that has, at least seemingly, had great interest in textual analysis and plain meaning has failed to consider the import of those words. Now, I'm no longer a judge. It would be very hard for the Congress to take away my pension, unless, of course, with the recent tax cuts, it can't afford it. So I'm going to express a few thoughts that I wouldn't have decided or articulated 2 years ago, but I'll try to stay roughly in turn. But okay, so let's now talk about those 10 cases, and the first one I want to talk about is actually not a code case at all. It's an act case, Katchen versus Landy. In that one, in an opinion by Justice White, the court held that the bankruptcy, I talk like bankruptcy judge, the referee had summary jurisdiction to order the return of a preference that was asserted by a trustee in response to a claim by, after a creditor had filed a proof of claim in the bankruptcy court. There are 3 things I want you to take away from Katchen. First, of course, the factual predicate. The target of the preference action had actually filed a claim. But remember, we're now talking in the days of summary jurisdiction. In general, a referee couldn't hear a plenary action. So how could the referee do it with his summary jurisdiction here? And by the way, there were so few women referees and bankruptcy judges back in those days that I may slip into a male gender, for which I apologize. But notice that the court didn't just uphold, taking by reason of that preference the claim down to 0. The court authorized an affirmative recovery of that preference. So, yeah, we can understand why, using its in rem jurisdiction, the referee could have said, uh-oh, you got a preference, don't bother me, don't bother the other creditors, don't dilute their recoveries, you don't get anything. The court authorized the money coming in the door. Interesting, especially in light of what you're going to hear down the road. Secondly, entirely missing from that decision is an expression you're going to hear when I talk about the 9 cases to follow: public right. We'll come back to that and try to get our arms around it, but you won't see it or hear about it in Catch. And the third important takeaway from my perspective about Catchin is that the opinion, which was written by Justice White, Wizard White, was a very pragmatic approach. He really cared about there being a functional bankruptcy process. As you hear discussion of those cases, you're going to see a pendulum that swings from that very pro-process approach, one that really cares about what's good for putting more money into the pockets of creditors and reorganizing companies, to one which is much more structural and institutionally based, and much less focused on what it takes to get the job done in a way that's efficient and fair. You will see for that reason that although that opinion was written by Justice White, pretty soon Justice White's going to start winding up on the dissenting side. And notice that pattern as we go forward. The next case is one that I'm going to talk about very quickly. It's one of 3 or 4 cases that aren't bankruptcy cases at all. It's called Atlas Roofing. The court unanimously held that challenges to OSHA orders, occupational safety orders, that were issued by an administrative law judge needn't offer a jury trial. And it talked about what we're going to hear more about, the public rights doctrine, which is a doctrine emanating from a case called Murray's Lessee in the mid-1800s, which basically said that when Congress was dealing with certain kinds of rights, and I'll be more precise when I read the exact language as I find it further on, which were of a public nature as contrasted to a private nature. It could set up the mechanisms for dealing with rights of that character as it saw fit. It could offer a jury trial. It could deny a jury trial. It could offer and have them decided by an Article III judge, or it could offer and have them decided by a non-Article III judge. That was a case in which a revenue collector who was supposed to be collecting revenues and ponying them up to the government violated his duty, and the court was dealing with the remedies for doing that. And it held that under those circumstances, because of the nature of that being a public right, and there the government was a plaintiff, a jury trial needn't be provided. Then we get to a case that at least everybody who's a judge or a practitioner knows well. Northern Pipeline versus Marathon Pipeline. This is the first of the postcode cases, and it comes up by reason of a statutory change not in the bankruptcy code, but in the judicial code, 28 U.S.C., which had given bankruptcy courts, and they were now called bankruptcy courts, jurisdiction of 3 types: arising under jurisdiction, which is a species of federal question jurisdiction, except instead of applying to the entire U.S. code, it applied to the bankruptcy code; arising in jurisdiction, which generally related to kinds of matters that would not appear except in a bankruptcy case; and related to jurisdiction, which would, in conceptual terms, be stuff that would have an effect upon an estate, but which would not fall within the first 2 categories. By way of example, bringing a contract case that would bring money into the estate, which would be of unquestionable desirability to the creditor community could be asserted only under related to jurisdiction. The court dealt with that, and I'm going to deal with it much quicker than it deserves. But in a decision that could not get 5 votes, the court held by a plurality decision that the judicial code provision, 28 U.S.C., I think it was 1371, excuse me, was unconstitutional in its entirety based upon its unconstitutionality when used as the method for bringing a contract claim, a state law claim, in the bankruptcy court. And it didn't get, as I mentioned, 5 votes, but there was a common thread by 2 additional judges who were concurring. And basically, we think of Marathon as standing for the proposition that the court held, apart from the fact that that whole section of the code, whether it was offensive in any other respects or not, could not be used to provide for a jurisdictional basis for an estate bringing a related to claim on a purely state law claim. Notice that it did not then address in any way federal question claims that might be brought that could bring new value into the estate or bring value back into the estate, such as fraudulent conveyance claims on the one hand or preference recoveries on the other. And the plurality distinguished in its discussion the restructuring of debtor-creditor relations, which I would suggest to you is a sophisticated way of talking about the in rem type of stuff that I was talking about before, which it described as being at the core of federal bankruptcy power, from the adjudication of state-created private rights. It was the state private rights characterization which brought the 2 additional judges in to what was effectively a 6-judge judgment that the statute as drafted could not stand. Now remember that expression I used a moment ago, the core of federal bankruptcy power that comes out of Marathon. Those of you, which I guess is most of you, who are judges or practitioners who still practiced in the days of 28 U.S.C. 157, where it really made a difference, will remember the expression core proceedings. And the expression core proceedings, at least in my judgment, had its origin in the distinction that was made in that fashion. Jumping ahead, and forgive me again for rushing. We then have 2 non-bankruptcy cases, Union Carbide and CFTC versus Shore, in each of which the Supreme Court upheld, said it was okay to have federal schemes in which tribunals other than Article III courts could hear claims for private damages, in the event of non-bankruptcy disputes. In Union Carbide, the court held importantly that it would no longer be of the view that for there to be a public right, that the U.S. government be a party to the litigation. 5 judges held that. For a long time during his lifetime, Justice Scalia differed with that view. He recognized the existence of public rights as providing an exception under which an Article III judge wouldn't need to hear a controversy, but he believed the government should still be a party to it. That view, which is understandable in light of much of its history, nevertheless was rejected by those 5 judges in Union Carbide and remains the law today, unless the court were for some reason to overrule its holding in that and similar cases. Jumping back now into the bankruptcy world, and we come up with a case called Gran Financiera, and for those of you who speak Spanish better than my high school Spanish, if I've butchered the pronunciation, excuse me, versus Norbert. That was a case in which the court held that parties who had not submitted proofs of claim in a bankruptcy case had a right to a jury trial, which is a first cousin of the issue of a bankruptcy judge's power to decide things. So we have the opposite of Katchen versus Landy. And I think the most important thing to think about Gran Financiera is not that holding, which is not all that surprising when you compare and contrast it to Katchen v. Landy, but other things that it said. Its initial premise was that unless a legal action involves public rights, Congress can't deprive parties of a jury trial. And also said that if a statutory right is not closely intertwined with a federal regulatory program that Congress has the right to enact, then it must be adjudicated by an Article III court. And if the right is legal in nature, then it carries a jury trial right as well. Now, by the way, most of the time we're talking about the rights of bankruptcy judges to decide stuff. Remember that federal district judges have that same subject matter jurisdiction that bankruptcy judges do. And it's a good rule of thumb, by the way, for you to analyze these issues by saying, well, if it weren't a lowly Article I bankruptcy judge dealing with this stuff, but were a district judge dealing with the same issue, would he or she have subject matter jurisdiction? Most of the time, on the type of things I'm talking about, a district judge would. But by the same token, if a claim is equitable, a district judge doesn't have to grant a jury trial right any more than a bankruptcy judge does. So think here about how the issues have slightly different application when you're talking about a bankruptcy judge's power on the one hand and a district judge's on the other. What the court also said, which wasn't so relevant in Financiera, but it's going to become more relevant, I think, in the next case that comes down the road, if indeed it's litigated. The court said, and this may be dictum, it may not be, although the issue admits of some debate, a bankruptcy trustee's right to recover a fraudulent conveyance under 11 U.S.C. Section 548A2 seems to us more accurately characterized as a private rather than a public right, as we've used those terms in our Article III decisions. That would at least seemingly suggest that bankruptcy judges have to be very careful in assuming power over claims to recover fraudulent conveyances, and I'm not sure if preferences would be regarded as meaningfully different. And that may be coming up down the road. The next case we can deal with very quickly, especially since it was per curiam, Langenkamp v. Culp. That involved a case where targets of a preference action had filed proofs of claim, and just like Katchen v. Landy, bankruptcy judge can decide the issue. But once again, notice that the court authorized two separate things, not just erasing the claim, not just saying, thou shalt not collect out of my bankruptcy estate, which I think most or all of us would agree is a classic in rem function, but I can pick your pocket and take that money back and give it to the remainder of the creditor community. So at least as long as Langenkamp v. Culp would remain good law, that capability still exists. And by the way, in such a situation, there's no right to a jury trial. Then we jump forward to Stern versus Marshall. And I think most of you know about it, so I'm only going to make a few observations there. Stern versus Marshall, as we know, holds that a state law counterclaim could not, consistent with the Constitution, be asserted against an entity even that had filed a proof of claim when there was not a full congruence between the claim that had been submitted to the bankruptcy court and the subject of the counterclaim. I'm dramatically overly generalizing, but I think what I said is sufficiently accurate. That was so, even though as a matter of statute, it was a core matter. It was expressly stated to be a core matter. And the decision was driven on an amalgam of some of the things that I've talked about before. It was not a public right. It was not an in rem action. And although the statute had said it was okay, it was an overreach by the federal judiciary. Particular concern was given to whether or not it was a public right. By this time, it was clear that a public right no longer requires the U.S. government to be a party. Nevertheless, public right had been historically understood as involving either one or another of three main categories. A matter where Congress had legislated with respect to territories that were not states, had invoked its power to prescribe rights relating to court-martials, or involved public rights. And we've talked about what public rights are. And we think we know what public rights are. They are either rights to which the U.S. government is a party or involve a federally enacted regulatory scheme for which the action is an integral part. Now, other concerns appear as well, that Congress might be aggrandizing itself, or putting it conversely, humbling the judiciary at the Article III judiciary's expense. But once again, we're talking about institutional concerns. And by the way, notice that nothing that I've said yet talks about the fairness of the proceeding. Proceedings of this character could be judicially reviewed by Article III judges, albeit under the deference on fact-finding that Article III judges give it. But they nevertheless could be judicially reviewed. With that said, the Stern versus Marshall Court stated, Justice Roberts speaking for the five-judge majority, "We do not think the removal of counterclaims such as Vicky's from core bankruptcy jurisdiction meaningfully changes the division of labor in the current statute. We agree with the United States that the question presented here is a narrow one. That's been paraphrased by many as saying that Justice Roberts didn't believe that Stern versus Marshall was a big deal. Well, any of us who has been in the real world for the last decade knows that that isn't exactly accurate. My former colleague, Shelley Chapman, wrote in one of the early decisions after Stern that Stern had become the mantra of every litigant who, for strategic or tactical reasons, would rather litigate somewhere other than the bankruptcy court. And in one of my early post-Stern decisions, I determined that I should abstain from a matter where I was concerned that the estate would be engaged in bleak house litigation, determining whether or not any orders that I entered could be regarded as final orders that the estate could enforce. Apropos that, I want you guys to think back to what Justice White cared about back in Katchen versus Landy about efficiency. The Supreme Court gave its view of that concern in Stern. It said, it goes without saying that the fact that a given law or procedure is efficient, convenient, and useful will not save it if it is contrary to the Constitution. I think it's also fair to say that dumb decisions by bankruptcy judges can lead to the necessity for Article III judges to deal with this stuff. The controversy that was decided at the bankruptcy court in Stern was a first cousin of an issue that was already pending in the Texas probate court. I don't know how many bankruptcy judges we have in the room now, probably half a dozen or a dozen. I suspect that each one of them would have given serious thought, if it were other than a no-brainer, to abstain from dealing with an issue of that character and not getting the U.S. courts into the pickle that they were thereafter in. Two other cases, though, and this will bring me to the end of it, and I hope I'm not talking way too long. I suspect I am. So, yeah, Jay's saying crank it up. Things get better. In the Aaronson case, the Supreme Court held that you could still provide proposed findings of fact for review by a district judge, and in wellness, the court held that parties could still consent to the final order of a bankruptcy judge. So thank God for that. What are our takeaways? One is already apparent. You see the swinging pendulum. First, from efficiency and what's good for creditors and their needs and concerns, to structural concerns, maybe back now a little bit to efficiency. Let's cross our fingers. Not much of a change? Well, I would suggest to you that it is still a change, as the need for Judge Levinson in Delaware to talk about whether Stern prevents entry of elements of a confirmation order suggests. But hopefully with some of the attention to reality that we now see in Aaronson and wellness, that'll be a little better. Objections to claims. There was musing in, first, in the oral argument in Stern, and then even in Justice Scalia's concurring opinion, asking, well, do you think that if a claim is asserted under state law, a bankruptcy judge can now decide it? Well, my suggestion to you is, of course he can, of course she can. And that if the law were to hold otherwise in light of the historical in rem jurisdiction of the bankruptcy courts, that question will answer itself if anybody really wants to press the point. The Bankruptcy Clause. I read it at the beginning. You haven't heard much more about it because you haven't heard much more about it from the Supreme Court. You know, Congress has the right to enact rules for the regulation of the armed forces. Based upon that, it has the authority to authorize court-martials. But the same power has not been applied in the bankruptcy area. So I could say more, but I see my friend standing very diplomatically. And if anybody has any questions at the end, I'll try to deal with them. Thanks for your time.
Thank you, Judge. I think you had perhaps the heaviest burden in terms of what you were trying to cover and some of the complexity, so we'll have some time for questions later. Professor, I think, are you planning on going next? Is that?
I think so.
Great, okay. Come on up.
I want to hear some from Jamie, but, so let me just set the table with a couple of things. I'm talking not about the jurisdictional stuff, but just about substantive issues and how the Supreme Court thinks about substance. And of course, a couple of preliminary observations. If they are confronting a discrete substantive area of the law, they're smart people, they have good law clerks, they will do good lawyerly jobs with respect to that particular issue. What I want to do, though, is try to say, well, ask the following question. What can we say generally about how they think about bankruptcy cases and how we should think about what they're doing and how that's different than the way they might address any particular issue of statutory construction? A couple of initial observations. They are not bankruptcy experts. They're not close to being bankruptcy experts. I should also say the Supreme Court is a they, not an it. There are a number of different lawyers who have different types of experience. Justice Kagan has almost none. Justice Breyer, Justice Ginsburg, District Court at the Court of Appeals at least heard a number of cases. So again, you don't want to overgeneralize. But one thing you can't do is go in and expect that they're really going to understand things like the difference between dip financing and exit financing. And you shouldn't also be shocked if they write an opinion that gets it wrong. You can say, what about their law clerks? Well, they all went to Yale. They never took bankruptcy. They won't know. So let me start with just to be provocative and give you what I think is the most important Supreme Court decision ever, which is Buckner versus United States. Now, Buckner versus United States has the interesting characteristic of being a pre-code case that is superseded by statute that deals with an obscure point of North Carolina lien law. Okay, so why am I talking about it? Well, that's like saying Erie is a railway case. The relevant language in Buckner is property interests are created and defined by state law. Unless some federal interest requires a different result, there is no reason why such interest should be analyzed differently simply because an interested party is involved in a bankruptcy proceeding. A party should not receive a windfall by happenstance of bankruptcy. In other words, the basic idea is when the Supreme Court looks at a set of non-bankruptcy rights, unless there's some specific bankruptcy policy that says they should do something different, they're going to respect that right. And that's the basic posture they're going to bring to every case. Even though it's been superseded by statute, I looked, it's been cited by the Supreme Court more than a dozen times. It's raised in cases like Weintraub that dealt with the attorney-client privilege, where what the Supreme Court does is say, well, wait a second, what's the non-bankruptcy analog? How do we think about who gets to assert the attorney-client privilege in bankruptcy? This is just a standard theme they used. I want to make two comments about bankruptcy history, and this is the jurisprudence from the 1930s, and this is a yin and a yang. In the 1930s, there were a number of cases in which the Supreme Court focused on the fact that secured creditors held property rights. They're not just senior, but they actually hold property rights, and they say that really matters. That has Fifth Amendment implications. We take property seriously. This is a theme that still resonates through the jurisprudence today, especially in an era where a majority of the court probably believes in federalism and believes in deference to state laws and so forth. Relevant quote from Louisville Joint Stock Land Bank versus Radford, which declared unconstitutional Fraser-Lemke Act. If the public interest requires and permits the taking of property of individual mortgagees in order to relieve the necessities of individual mortgagors, let me just translate that. If the public interest requires and permits the taking of property of secured creditors in order to relieve the necessities of individual debtors, resort must be had by eminent domain. Now, I'm not saying that that's the way the Supreme Court's going to talk today, but that's a shadow that the Supreme Court will cast over any time Jamie comes along and wants to take away my right as a secured creditor. Something that has dramatically changed, however, is if you read the Supreme Court cases of the 1930s, you'll see repeated references to the Statute of 13 Elizabeth, the old standard fraudulent conveyance statute. They'll talk repeatedly about how bankruptcy courts are courts of equity. Bankruptcy courts have the power to figure this stuff out. Bankruptcy courts have the power to fashion remedies. And this is where we get the origins of substantive consolidation, of equitable subordination, of various things like that. That's the way the Supreme Court talked about bankruptcy judges in the 1930s. That's not with us today. That's not the way the Supreme Court is thinking about bankruptcy judges today. The standard theme of bankruptcy jurisprudence is repeated decisions by the Supreme Court to limit the discretion of bankruptcy judges. And they'll do this in cases like Radlax is a good example. There's interpretive ambiguity, and they say the Bankruptcy Code says sales with credit bidding. That's the only way you can do sales, period. That's a natural move they make. You can point to these cases where they do it over and over again. To cite Justice Robert, he is being confirmed. He was talking about all judges, but he means it specifically with respect to bankruptcy judges. They should just call balls and strikes. What they want is that you respect non-bankruptcy rights, and when there's a federal bankruptcy policy that requires a different result, that's fine, but you have to tell me where in the bankruptcy code it says that. You can't say, gee, this will maximize the value of the estate. The court said, no. We're not talking about a general right to give the debtor a windfall by happenstance of bankruptcy. Show me a particular right, and if you can show me a particular right in bankruptcy, that's fine, but unless you can identify a particular provision of the bankruptcy code, I'm going to define the power of the judges narrowly, and I'm going to take as my baseline non-bankruptcy rights. And again, before people get upset, remember, I'm not giving my view. I'm talking about the general posture the Supreme Court takes to that. Maybe I'd say the same thing if I were in the Supreme Court, but I can guarantee you that that's never going to happen. At any rate, what does this mean for, let's say, secured creditors in particular? I think if you want to cut back on the rights of the secured creditor in the Supreme Court, you have a very long road to hoe. Unless you can point to some particular part of the bankruptcy code, nothing in particular is going to happen. The caveat I would give to that, and this is just to talk about cases like Till, is that when it comes to valuation, things are a little bit different. The Supreme Court in Till, remember, said that you have a Chapter 13 plan where, in expectation, 70% are going to fail. And the Supreme Court said, well, let's calculate an interest rate that takes account of that probability of failure and that fully compensates the secured creditor for having a debtor with a 70% chance of defaulting. Well, you need to give a risk premium for that. And the bankruptcy judge has discretion to figure out when there's a 70% chance of failure, what kind of risk premium compensate. Could be 1%, or 2%, or 3%. And again, that's not the way, that's not seriously valuing the secured creditor's right. But I think that may be the wrong lesson to take away from Till. I think the right lesson to take away from Till, and this is another part of Till, where what they say is that, wait a second, if that kind of risk premium isn't a reasonable risk premium, if the kind of risk premium you need is really eye-popping, that says something about the Chapter 13, not about the interest rate you should be charging. At any rate, I think there's a lot of play in the joints when it comes to valuation, but I don't think it's like the play we saw before the code where courts would play with valuations in order to put a thumb on the scale. This is a situation where the Supreme Court is doing valuations without necessarily being anchored on planet Earth, which is somewhat different. But at any rate, Jamie disagrees with everything I said, and I want to give him a chance.
Only half. Okay. Thank you for having me here. I've been asked to talk about the absolute priority rule, and lucky for me, the Supreme Court hasn't actually talked about it that much. I'll go through a couple of things, but one, Judge Gerber mentioned Northern Pipeline, which I hadn't heard mentioned in a while, and I just, anecdotally, I started practicing law in 1985, and I was a summer associate in 1984, and for those of you who remember, the Northern Pipeline came out in 82, and they ruled the whole system unconstitutional, but they stayed it and gave Congress a chance to fix it. Of course, Congress didn't. And I think they gave them a 1 year, and then they extended for 6 months, and then in the summer of '84, they let it go into effect. And I was a summer associate. And they actually shut down the bankruptcy system. And I see some other people who were in Chicago at the time, and I remember I was a summer associate going over to bankruptcy court, and the judges would sit at the counsel table without their robes on and say, well, there is no bankruptcy system, and I'm not a bankruptcy judge, but if I was, here's what I might do in this particular instance. And amazingly, it worked pretty well. That only went on for about 6 weeks, but it was an interesting time to be a summer associate. So in any event, so the absolute priority rule. So that rule, or the rule itself, predates the Bankruptcy Code. And it was enacted, like a lot of things with good intentions, with the belief that insiders, with the support of sometimes other creditors, could use the bankruptcy process or reorganization process at the time to get some sort of unfair advantage. The pre-code law, which goes back literally to the first case was 1899, Louisville Trust, and there was another case in 1913, Northern Pacific v. Boyd, basically said that, kind of what the absolute priority rule says today, that according to principles of fairness and equity, creditors have to be paid before stockholders can retain any equity interest for any reason. That was codified, as everybody knows, in 1129B1, which says virtually the same thing. Now, I think everybody knows this, but sometimes I think people lose the focus. That only applies in a cramdown. Obviously, people can agree otherwise. So what's the Supreme Court had to say about the absolute priority rule? And what's interesting is most of what they've said is sort of evasive and dicta or unclear exactly, the binding nature of it. So you go to Los Angeles Lumber Products Company from 1939, which even though it's a lumber products company, it built ships. This was dicta, and they said, not that the absolute priority rule doesn't exist, but you could have, and this is where the words get interesting, is it a corollary, is it an exception? Here it was a deviation from the strict application of the absolute priority rule, where the necessity for new capital exists and old stockholders make a fresh contribution and receive equity in return for a participation reasonably equivalent to their contribution. No objection can be made. But in this one, the court actually denied confirmation of the plan because they didn't find that the stockholders had contributed any new value. So they kind of made up something and dicta and said, well, it doesn't really apply because they didn't do it. And then going forward from that, the lower courts, trying to figure out what that case meant, said the Second and Fourth Circuit rejected the concept of there being new value plans. And the Seventh and Ninth Circuit said there could be new value plans. So the Supreme Court weighed in again, 60 years later, in 1999, in 203 North LaSalle, which everybody has heard of, which by then happened to be the building I was practicing in Chicago at Rudnick and Wolf, so I thought that was quite appropriate, which later on became DLA. There, the Supreme Court, again, acknowledged the existence of the new value exception as a, they used exception and then they used corollary, but didn't rule on whether it existed or not, because they said whether it existed or not, if it did exist, in this case it wasn't satisfied because there wasn't a market test of the new value being put in by the equity, and thus they didn't really need to decide whether the new value corollary exception existed. Since then, there's been a bunch of lower court cases, not that many even circuit court cases, trying to divine exactly what that means, what's a market test, and things like that. Then along comes, pretty recently, Jevic, which is not quite an absolute priority rule case, but you could argue it a few different ways, but that was a structured dismissal case. and I will note that my firm argued it and lost it. It's interesting what it's being interpreted now by the lower courts, pretty frequently. And Supreme Court there held the non-consensual structured dismissal could not include a transfer of state assets that violated the absolute priority rule. And it held that nothing in Section 349 of the Code authorized a bankruptcy court to make general end-of-case distributions that would be flatly impermissible in a Chapter 7 liquidation or Chapter 11 plan in violation of the absolute priority rule without the impaired creditor's consent. That's the cramdown, only if it would be a cramdown. Interestingly, they distinguished the holding from the Second Circuit's decision in Iridium. Not only did my firm lose that case, I argued it and lost it. So it's another one. And in that one, the Second Circuit affirmed a pre-planned settlement that provided for a distribution to junior creditors over the objection of more senior creditors. Basically, what happened was there was and I remember this pretty vividly. I remember actually when I went in to argue it in the district court, I was sitting on one side while Gotcha was sitting on the other side, and they were supposed to go first. And the judge said, "Mr. Sprayregen, you should come up here first because you're the one who has to tell me why I shouldn't rule for them." It didn't start out well. That was the district court. We lost there, and we lost in the Second Circuit too. But what the Iridium court had held was there was a desire to go after Motorola. This was the Iridium phones. Motorola wasn't the bankrupt, but they had funded the bankrupt entity with a lot of money. But the Iridium creditors wanted to sue Motorola for a lot more money. And they put aside a bunch of money in a trust to fund the lawsuit against Motorola, even though Motorola had a first lien on all the assets. A disputed first lien. I didn't think it was disputed, but they thought it was disputed. In any event, they held that that was okay, even though that couldn't have been done under a plan of reorganization. That's a Second Circuit case. It's not a Supreme Court case. But in Jevick, the Supreme Court said, no, what was done in Jevick was an end-of-case distribution, and in Iridium, it was middle of the case or something like that, and that's distinguishing. And because it only involved an interim order and that the distribution funded a litigation trust to press claims on the estate's behalf to create more value for the estate. And so they recognize that non-consensual departures from ordinary priority rules can be approved where they further legitimate code purposes. And they also, I think in thinking of what the mischief they'd wrought in Stern, I'm not sure if they were thinking about this, but after they did Stern and then it ended up looking pretty broad, and after a few more cases that took their way to wind to the Supreme Court after a few years, they did make it kind of narrow, even though Justice Roberts had said it was supposed to start out narrow. Here, again, they said that there's numerous instances where interim distributions can violate ordinary priority rules. And they talked about first-day orders. And really interestingly, we all know as bankruptcy jocks practicing in the lower courts that roll-ups can be kind of controversial. Here they talked about roll-ups as being part of the normal things that are approved as interim distributions. So speaking of protecting secured creditors, if I'm a secured creditor, I would read that and say, I just got licensed to go do roll-ups.
I would read it and say they don't really know.
I know he disagrees. You're going back to Till's 1%, you're saying? So they found that the structured dismissal in Jevick didn't serve any legitimate code purpose and violated the absolute priority rule. And those are really the Supreme Court cases that deal with the absolute priority rule. So I can't go through the however many cases Judge Gerber went through to divine what all of this means. You know, as a practitioner sort of toiling in the vineyards, you know, my experience, and you look at an Iridium, which I was on one side of, Jevick I was on the other side of, there's a constant, and again, it's similar to what you said, Judge Gerber, with this push me, pull you, tug between practicality, commerciality, and adherence to what may look like the exactitude of the code, but when you really burrow into it, is it as exact as it seems? If everybody gets on board, it actually doesn't matter. and because you don't have Cramdown, and so you don't have that issue. If somebody's holding out, Jevik's an example, everybody was on board except for there was a class action group of plaintiffs, of warned plaintiffs, actually. And for anybody following it, there's a motion now to approve a new settlement in the Delaware Bankruptcy Code in Jevik that basically stops the skipping of the absolute priority rule. I'm sorry, skipping of the warned class and gives them a distribution. And they're actually objecting and says that still violates Jevik, just convert the case to Chapter 7 because that's what the Supreme Court required. And we're prosecuting that settlement, so I have my own view on it, and that actually complies with Jevik because it does exactly what Jevik said you need to do to be able to have a structured dismissal. We'll see what the bankruptcy judge in Delaware does with that. So maybe I'll stop there because a little bit of time for questions, I guess. But to me, the dearth of authority from the Supreme Court in the absolute priority rule context, which is one of the key provisions or key, almost philosophical conceptual underpinnings of the code, is kind of striking. And even where they have it, Los Angeles Lumber is dicta. The decision in 203 North LaSalle is, if it's not dicta, they just said it didn't really apply. And now we have Jevik where it wasn't even a plan of reorganization, it was a structured dismissal. So it's kind of, quite the mishmash of trying to figure out how to deal with it. Maybe the lesson is make deals and don't go to the Supreme Court.
So we have about 10 minutes for this session, and I'm glad. I'm going to sort of throw out a couple of things and then open it up to the floor for some questions. Let's start with what we call jurisdiction, but really is power, and I hope everybody sort of understands the distinction here. Nobody's really contested the bankruptcy jurisdiction in Stern v. Marshall, right? The question was whether you could have an Article I judge decide that issue or whether it had to be decided by an Article III judge. And I think people confuse jurisdiction and power here. But there have been some cases post-Stern versus Marshall that have talked about, well, let me give what I think is a difficult example and one that could really throw a wrench in our practices. The notion that a plan of reorganization that resolves third-party claims, that provides for injunctions and releases of third-party claims that themselves are Stern-type claims that would not be capable or arguably not capable of being resolved by an Article I judge. Can a plan approve that, or do you need to get that plan blessed by an Article III judge, as was done in MMA, Bob, to protect against that issue? Is that the only way? And I'd love to hear from the panel, and I'd love to hear from the audience about some thoughts about that.
So you're assuming third-party releases are okay?
I'm making that first assumption, that a plan, most of the circuits say
have a
that in
problem
some
with
circuits.
Well, we have a case that's still pending, Millennium Health, which went to the Third Circuit on precisely that issue, and they said, yes, it is okay for the bankruptcy court to determine that. Now it's, again, working its way back up to the Third Circuit again on corollary type issues. But I think, especially the way Stern has been clarified subsequently by the Supreme Court, that yes, the bankruptcy court can do that without going to the district court.
I don't have a dog in that fight, but I agree with you, Jamie. It's interesting, in wellness, Justice Alito concurred in the result, and he did it because he recognized there's still an NREM aspect to what bankruptcy judges do within the bankruptcy administration of the estate and confirming plans as a poster child for what you're talking about. And I think that confirming a plan is a classic NREM exercise, and I think she got it right.
I would say, interestingly, we didn't mention this at all, but, the root of all of this mess is the refusal to make bankruptcy judges Article III judges. If we didn't have that issue, this entire panoply of stuff. It wouldn't exist. I would say, interesting, I was on the ABI Bankruptcy Reform Commission, and we came out with this proposal after 2 years, 314 suggestions, not a word about what should be done about Article 1 judgeships. Why? Because we figured that was politically dead on arrival in the Congress, and that it's just not going to get dealt with. And so we're going to keep having these types of issues.
Professor, you have any different view on that about plans that contain third-party releases and injunctions of claims that are Stern-type claims?
Well, again, I hate doing it, but I would channel Jamie and say that
Pains him to do
the best way to handle third-party release is to have a consensual plan, put it in the plan, hope no one objects, have the plan confirmed, and then, you've never done that before.
Bob?
Yeah, I mean, just because you made the MMA reference, I mean, the interesting thing in MMA, of course, was by the time we got there, we had a consensual plan, but we were also pre-wellness, right? So in order to actually convince the tort defense bar, which was largely advising the companies who were giving us money, that they could rely on any of this stuff, we put a provision in the settlements that we would go get a district court order that blessed things in the end. Not because, frankly, we thought we needed it, but because in order to make the tort defense bar cough up the funds, they wanted to see that provision, and eventually it became a provision that CP needed. But I mean, as Judge Carey will remember, he kind of looked at me quizzically when I suggested we had to go to the district court, because I think he was perfectly comfortable with the fact that he had authority, as was I. But we had a broader universe, sort of beyond the bankruptcy universe, that we had to convince, and that's really where it came down. It might have been a different case after wellness, which it was by the time we actually got the final district court order.
So I think the district court judge was a little perplexed too, wasn't she, about why she was being asked to do that?
Well, she was, and then her successor as well, yeah.
Yeah, but if it was an asbestos case under 524G, it would have been de rigueur to go do it. And that's how you get rid of all that issues there. That basically, they solved the Article 3 judge problem in 524G that way.
One thing I can tell you is that Jamie and I both, I can't speak for you, but we began in Chicago in 1985 together. And I can't tell you how much time I spent in my first 5 years of practice litigating withdrawal of reference motions. I mean, that's what we did. And there were time limits. If you didn't do it soon enough, then, you were basically say you had waived it and consented to the jurisdiction. And if you did it too early, they said, come back and see me when it's trial ready. There was no good time to bring it, but you had to bring it early because otherwise you were at risk. Judge, no, please, go.
I was going to say, when that came up, I thought, wait a minute, I'm a new bankruptcy judge. I thought I had the authority to do this stuff.
So let me throw another one out there in our last couple of minutes. There's discussion about valuation, which I think is tied into much of this. Till. Now, it was a Chapter 13 case. There's been a lot of discussion about whether it applies in 11, but most folks seem to think it does. I'm a bankruptcy litigator. I look at Till, and I think about a valuation, an appraiser or valuation expert coming in and testifying about the adjustment in the interest rate that ought to be made between 1% to 3% on the basis of Till. And if it were me, I would file a Daubert motion to strike that as methodologically flawed. It is not what any appraiser, MAI, or valuation expert would do in a million years. The person would analyze the business, the risk, comparable companies, and try to establish an interest rate. Or, as many courts have done, Judge Gerber, you may be familiar with all these, the blended rates, where they would say, well, okay, bankruptcy contemplates a forced loan. So for 75 or 80%, we're going to look at the market rate for that, a well-secured loan, and we're going to assign an interest rate. And for the next 10%, we're going to treat it as mezzanine financing and look at the interest rate. And the last 10%, we're going to treat as capital and looking at an equity return, and we're going to blend that. That's been rejected by most courts at this point. But I think that there's a real problem with Till and its methodology in terms of valuation and interest rate. So any thoughts about that?
Well, I think, again, maybe a lot of bankruptcy courts have rejected it, but I think if you get a large reorganization. Also, the Second Circuit has ruled on this, hasn't it?
Yeah, momentum.
Momentum, and so I wouldn't have any confidence that people in 11 are going to mechanically follow Till. I think that the frightening thing in Momentum was that as Judge Drain was issuing his opinion, you could watch in your Bloomberg terminal as the price of this bond that was supposed to be worth 100 just dropped to 85. You have to say, if you're supposed to give a piece of paper that's worth 100 and that paper is being traded, and you see the price fall below 85, that's a problem. And that's a problem that's going to register in a large Chapter 11 when there's a lot of money and the robust markets and things like that. I think an opinion like Till lives in the Chapter 13 context just because no one is really providing reality therapy. And I don't think it'll survive in the 11 context if it actually gets to the Supreme Court.
I mean, I would say two things. One, the facts matter, although a lot of times at the Supreme Court they don't. But there's an element of pigs get fat, hogs get slaughtered, and Momentum. The Judge Drain ruled against them and imposed Till after the same creditors were offered cash in par plus accrued for their claim, but they had to give up their make-whole. So they said, no, I don't want to give up the make-whole, so they said, we'll take a note instead. So, I don't think emotion played into it, but they were offered, they could have got everything they were entitled to, because the make-whole was later found to not be any good. So who knows exactly. The other thing I've always found very interesting about Till from the Supreme Court, apropos to your point about they don't understand bankruptcy or valuation or your Daubert motion, is they say maybe it doesn't apply in 11 because 11 you might have an efficient market, whereas in Chapter 13 you don't. Well, it was a truck loan. There's hundreds of thousands of truck loans a year. That would seem to me the most efficient market I could think of. You're from the University of Chicago, aren't you?
Yeah, and you're not going to get a 3% risk premium from any lender for that kind of loan.
But to say that was an inefficient market compared to a Chapter 11 market, I think is interesting. I think that's it's backwards.
No, they had, but again, they had a prime rate, and they even understand that the prime rate's not a secured rate. I mean, there are if you were grading the Till opinion, it would.
Well, one of the things, we're going to take a recess for 14 minutes. One of the things that's really neat is that many of the cases that you have heard about discussed here, the more recent cases, the last 15 or so years, you're going to get to hear on the next panel from the people who argued them in the Supreme Court.